5 seconds to go. Start. With the consent of the parties, an order dated 21st March 2002 was passed in the said proceeding appointing a sole arbitrator who was subsequently replaced by another arbitrator. Wide arbitral award dated 17th February 2005, the claim of the respondent company was allowed and a sum of rupees 7 crores 43 lakhs 46,772 only was awarded in its favor, which included interest at the rate of 18% per annum up to February 2005, along with future interest at the rate of 18% per annum payable with effect from 1st March 2005. Aggrieved by the aforesaid award, the appellant state filed a petition under section 34 of the 1996 Act before the District Judge, Raipur. Wide order dated 14th March 2006, the learned District Judge declined to interfere with the award except for modifying the same to the extent of the interest awarded in favor of the respondent company and making it payable from the date of the notice, that is 6 December 1999, instead of from the date of the agreement till 31st December 1999. The appellant state assailed the order dated 14th March 2006 by preferring an appeal under section 37 of the 1996 Act. The respondent company also filed a cross appeal, being aggrieved by the modification of the award and reduction of the period of interest awarded in its favor. Several pleas were taken by the appellant state in the appeal, including the ground of non-joinder of the state of Madhya Pradesh as a necessary party, that the respondent company never claimed refund of the excess recovery throughout the tenure of both the agreements, and that the respondent's claim was barred by limitation. A plea of estoppel was also taken against the respondent company. In view of the order dated 30th April 2010, whereunder leave was granted in the present petition limited to the issue of disallowance of supervision charges to the tune of rupees 1.49 crores under the award, which as per the appellant state was liable to be borne by the respondent company under the agreement. This court does not propose to examine the other pleas taken by the appellant state in the present appeal. Ms. Prerna Singh, learned counsel for the appellant state, has contended that a perusal of the terms and conditions of the agreement make it apparent that the parties had agreed that the expenses incurred every year by the state government for supplying sal seeds to the respondent company would not only include the cost of collection, purchase price paid to the growers and commission agents, cost of storage and transportation, but also include handling and supervision charges. She pointed out that the said plea taken by the appellant state was duly noted by the learned arbitrator in para 18, but was erroneously turned down in para 19 of the award. Paras 18 and 19 of the award are extracted herein below for ready reference. The further submission of the defendant is that in clause 6b of the agreement, in respect of supervision expense, it is mentioned, and the provision also enjoins that the supervision expenses along with other expenses which are spent by the defendant would be recoverable. In so far as the supervision expense is concerned, that concerns will all those expenses with respect to collection of the sal seeds under the banner of the government, and in these expenses there are certain expenses like go down rent, the salary of the officers and the staffs, the appointment of the different persons of the work in the department and their travelling allowance, vehicle, telephone, furniture, transport and all other expenses of the vehicle. They are all such proportionate expenses which cannot be shown under the head of the bill or the voucher under the head of sal seats, and therefore 10% supervision expenses are acceptable and recoverable. On the analysis of this issue, there is a clear provision in the agreements that the purchase of the sal seats shall be divided into two parts. The first would be of royalty and the second part would be of the purchaser of sal seats and all those expenses until its delivery, in which the collection expenses, purchasing price, handling and supervision expenses, the agent's commission, transports would all be assembled. After the examination of the price on both the ends, the first end would be of royalty according to the industrial policy of the state government of Madhya Pradesh. The meaning of royalty implies the meaning the price at the production side. For the calculation, the bazaar rate or the auction or the price received on tender, the transport in wood, matter the cutting expenses may be reduced. In this was in the matter of royalty from the point of production and protection and until the arrangement for the sake of trading all indirect expenses. Stop.